This meeting is being recorded.
So I guess we can start. So good afternoon, everybody. My name is Hanna Onderkova. I'm head of IP at EBTC, and I welcome you all for the next session of Thursday Talks, which we have been as EBTC jointly organizing with Magic, Tata Technologies, and ICONN, and of course CII. So of course, you know, as a small startup SME, the knowledge about how you have to structure your contracts, how you have to structure entities is very essential. So we are very happy we can discuss it at this platform. So before we go any further, I would like to pass word to Mr. Ashish Garde, from Managing Director of Magic, to share a few words with us. Sir, over to you.
Yeah, thank you. Good afternoon to all, and I take this opportunity to welcome you for the next episode of this Thursday Talk series. I'm sure this Thursday Talk series is very useful to all the participants. I'm sure some of them would be attending all the sessions. Whatever I'm going to say may be slight repetition to them, but for the benefit of those who are joining for the first Thursday Talk series session, I will quickly introduce Magic. Magic is a business incubator and SME accelerator established by members of Chamber of Marathwada Industries and Agriculture CMI. It's a sector agnostic incubator and SME accelerator, and we provide end-to-end support services to startups right from the stage of idea to their commercialization. We are in operation since 2015, and post-pandemic we are catering to startups all across India virtually also. Currently, we are incubating 38 startups, and more than 138 startups are connected virtually. We have very strong startup ecosystem created by signing MOUs with leading organizations and partner organizations like EBTC. Total, we have got in excess of 40 such MOUs and partnership in place, and we are active with all the partners. We conduct many sessions for imparting knowledge and sharing useful information with startups and potential startups. We conduct annual innovation challenge, which we would be launching very shortly for this year, and with the support of our ecosystem partners like HGGS College, who are with us today, we conduct many sessions in various academic institutions. The Magic is an industry-led incubator, not an academic institution hosted incubator, but we are very well connected with all academic institutions in the region. I take this opportunity to welcome Professor Joshi and Professor Gajre from HGGS College, and also today's speaker Siddharth Mahajan. This particular session series is planned as part of our collaboration with Tata Technologies, wherein we are conducting a virtual exhibition in collaboration with CII, wherein all the startup ecosystem players are present in a virtual exhibition, and we are promoting startups from Tier 2 and Tier 3 cities, and especially student-led startups. And I'm sure this Thursday Talk series will be very useful to even these student-led startups also. Thank you. Over to Anna.
Thank you, sir, for this lovely introduction. I think we can kick off with the session. I think we have, as you said, this is Magic's partners, and we have done a number of sessions together. So this is the next, hopefully, successful encounter. So the topic, as was already mentioned, is foundation of legal contract, and obviously the person who will be talking about it is someone who's very with vast experience over 16 years. And, as it has been advising in terms of joint venture, private equity, venture capital, and so on and so on. So he's definitely the right person to talk about. So I will kick off the session with the first question, because as I mentioned, we have a small startups here, people who are just coming, or students coming up with idea, they want to form their company, or and they might be kind of maybe wondering what are the different structure for MSMEs or startups to function in India. So Sinhad, over to you.
Hi Hannah, good afternoon everyone. Thank you for the introduction, and the kind of work with Magic is doing is really commendable, because startups in tier 2, tier 3 cities in India do not really have this kind of avenues to gain so much insight and knowledge into various things. So they are normally at disadvantage. So now coming on to the question, see, once you decide, somebody decides to start some kind of a business, so obviously you need to decide on how you will run that business. So running that business, that decision is very significant, because once you decide how you will run it, then only your future course of the business depends on that. So under the Indian law, there are various ways in which you can run any business. It's whether it is a big industry, MSME, or startup. Any business can either be a private limited company, where essentially you need 2 shareholders. It can be a partnership firm, a partnership which could be registered, or an unregistered partnership, but it is advisable to get it registered. Third option is to have a limited liability partnership. So limited liability partnership is a cross between the company and a simple partnership. So it has benefits of partnership and benefits of the company. It is also a different entity from its individuals. And the most common business structure which we see in India is the sole proprietorship, where the person in his or her own name just starts doing the business. So basically these 4 or 5 options are there under which you could start your business. So each of these, like company and a LLP, you need to get it registered with the registrar of companies. There are certain compliances which need to be done. With regard to partnership, there could be a simple deed, a partnership deed which could govern your relations, but it is advisable to get that deed registered, because legally then your partnership can sue other companies and in its own name. And sole proprietorship, as we all know, if it's a small business, most people, rather than getting into the complex structures of registrations and compliances, they prefer to do a small business in their own name. So these are basically different structures which operate in India for different businesses.
This is just me thinking loud. If, let's say, I am a small startup company and I opt for one of those structures, and at some point of time I found out it doesn't fit my needs, is there any way for them to change it at some point of the time?
Yeah, there are options. You can convert your LLP to a company and a company to a LLP. But these are 2 structures where you need to register with the registrar of companies. Companies registered under the Companies Act 2013, and LLPs are registered under the LLP Act of 2008. But for rest of the structures, if I'm running a partnership or a sole proprietorship, I will basically have to convert it into a company or into a LLP, get it registered, and carry on my business with that.
So would you say, before we go any further, that it's advisable to talk to some sort of lawyer before the students or the small companies decide how they want to proceed? Or you think they just can do it, online on the internet? Or would you say it's better to discuss it with somebody before I actually do it?
I think it is very important that you discuss it with some kind of an expert, maybe a lawyer or a chartered accountant, who could give you a perspective. See, at the end of the day, it is very important that what kind of business you are in, and what is your aspiration with regard to that business. So based on that, you could get a specific advice that what is the best possible structure which is suited to you. So I think it is very important to talk to a lawyer, because he will then advise you on various other compliances, various other things which you could do, some benefits which could be accrued to you. So I think it's important to talk to expert.
So, and I think that naturally brings us to the other question, which what should be considered, when you're actually deciding on that structure.
See, once you've decided that what kind of business you want to do, it is very important that while deciding on the structure. So one thing we need to keep in mind is that the most common and most hassle-free structure is a private limited company. Now, why I say that is that private limited company, the liability of an individual is only limited to the amount of equity which he holds in that company. Company is a distinct entity from the individual shareholders or the directors. So as the business expands, obviously your liabilities, your obligations, those things expand. So in that regard, the limited liability company, which is commonly called as private limited company in India, is the best possible structure. The other thing is the limited liability partnership, which, as I said, is a hybrid between the company and a partnership. It is also a distinct structure where your liability is limited to the amount you are holding, your contribution to the partnership. So this also helps. Besides these two structures, in all the other structures, you are personally liable for the success or failure of your business, which means that in case something goes wrong, your personal assets could be taken over, and you become personally liable for success and failure of the business. So how to decide what you want to do? I think it is very important that what kind of business you are doing, what is the type of business. If you get into a business which is complex, where there are many distributors, many vendors, you have a manufacturing company, I think in those cases, definitely you should go in for a company or a LLP. Second important consideration is what kind of capital you require. Do you require capital in future? Do you have your own capital, or would you require some investors in future who will pump in money? So if you need that, then again the company becomes a very important vehicle, because in company you can allot shares to others. This flexibility is not there in other entities. So basically somebody invests in your company at X valuation, and you allot shares to that shareholder. So it is easy for the investor also and for you also. Thirdly, if it's a small business, say somebody wants to do some retail business or a very small localized business where there is not too much capital requirement, and it is friends and family who are doing it, I think in those cases you could start off with the sole proprietorship business also and expand it. So basically it depends on what your vision is, what kind of business you want to do, how big is your business, and what kind of liabilities you are willing to take with regard to that business.
So if you kind of sum it up, particularly for students, or small startups which are just starting, which structure do you think would be the best? The sole proprietor, if we just kind of do the generalization?
I think the company is the most preferred structure.
Company, okay.
Because I'm not a tax expert, but there are certain tax benefits which company and LLPs also offer. So company, I think, is the most beneficial structure, where I think your liability is also limited. If the business succeeds or fails, company is a distinct entity. So it is always advisable that one starts off with the company. Okay.
So if we have somebody who is just planning to start up their own business, I guess this is the advice just for you. So of course, when you talk about companies and we talk about legal stuff, if I put in layman term, there are of course compliances which we as company owners have to think about. So what are the few examples of compliances which you can share with us which will have to be kind of complied with by the startups and SMEs?
Yes, see, essentially, when you set up a company, there are certain compliance requirements which you have to follow. And those with regard to the registrar of companies, there are certain secretarial compliances which have to be done. Your board meetings have to be done. Your annual returns have to be filed. And before doing all this, there are certain other compliances which you do while setting up the company. So those compliances are there. In LLP also, there are certain annual compliances which you have to do. Besides these are the compliances which are required so that your company remains active. Then there are obviously tax compliances which you have to do. Then there are if you get registered under Msme Act, there are certain compliances which you need to do. Then there are certain compliances under specific businesses, like if you are into food business, you need to take FSSAI licenses. If you are into a pharma business, there are certain licenses with drug controllers. Similarly, for chemicals, for manufacturing, you may need certain environmental clearances. So all those compliances have to be done so that your business is in good remains in good standing. And these compliances are also important because in future, if you want to get an investor to your company, when they do the due diligence and when they have a look that you've complied with all the compliances which are required for your business, obviously you are a clean business and they are more interested in investing in your company rather than in any other company where the compliances have not been done properly. So additional compliances could be with regard to your employees, number of employees you keep. Based on that, various labor laws kick in. And also compliances for service industry, you may have certain local municipal compliances with regard to shops and establishments and all those things. So yes, in India, businesses do need a lot of compliances. But that said, once if you are registered with MSME or with Startup India, there is certain leeway and certain benefits which are given to you, which may help you in reducing the cost of compliance and giving you certain additional time to comply with those requirements. In addition, you need to protect your intellectual property, whether it is your trademarks, brands, patents, which is quite important, especially for the startups.
I think it's kind of interesting that you are mentioning it, because if we obviously have a lot of startups who are watching us, and I'm sure everybody's dream is to make it big. But if, the vision is in the future that, I will become a unicorn or I will sell my technology to somebody, as you mentioned rightly, there have to be a proper way how you start your business pretty much from the beginning, that it should not go by the Jogara road, that somehow it's going to happen. I think this is a good kind of point to highlight, as you mentioned, that, if, there is a space for growth in the future, you will be checked what you have been doing in the past, right? So I think this is a kind of important takeaway for somebody who is just thinking about it. And I'm sure for the small businesses or, students, it might be pretty overwhelming, the amount of information and which has to be done. But as I said, there is a help for startups through various organizations to do that. And I think since you mentioned intellectual property, we had a number of these for taxation, we had a number of these webinars for these various topics as well. So I think we can now proceed, because at some point of the time when this company or startup grows, they obviously have to have some contracts in place. And I think you are the best person to really talk about what is the significance of contract for MSMEs.
Yes, so contracts or a legal agreement, I think, is the most fundamental requirement for any business. Although in India, we see in a lot of cases that people do rely on their oral agreements and on their existing relationships with people. But increasingly, what happens is, as you grow, number of people or number of things with which you are dealing grows exponentially, and you cannot have oral contracts or business dealings based on your existing relationships with people. So it is always advisable to have proper contracts for various things, and these contracts really help you in avoiding disputes in future, in basically having a clarity of business relationship between two entities or between two people, so that each entity or each person who's part of that contract knows exactly what he has to do, when he has to do, what he will be paid, when he will be paid. So all these things are very, very important, and well drafted contract really leads to a situation. It leads to avoidance of disputes. And in case a dispute happens, the parties do know that what the recourse is and what they can do. So if I know that if I'm clear that I have this liability, I will probably try my best not to break that contract. And if I have a legal contract, I can very well go and enforce it against a company or against a person who is not fulfilling his obligations under the specific contract. And contracts really give clarity and direction to a business relationship. So I think it is very important for MSME or any company, especially startups, that they enter into contracts so that there are no disputes. Because see, the vision for startups is to grow, and in future get more investment, get more funding. So obviously, if you do not have proper contracts in place, any investor will think twice before investing in your company, because he will not be sure that what your obligations are towards any third party. So it is very important that these things are captured in specific contracts, so that any investor coming to you is well aware that these are your clients, these are your obligations, these are your vendors, these are your suppliers, and you have these obligations. Because it is really not looked well in future if suddenly some new obligations come up. So that is important from the startup perspective. But from any business or MSME perspective, it is just a tool to give a clarity in relationship between two entities. And if something goes wrong, you know what the recourse is. Because otherwise, it is very difficult to pinpoint that if there is a default or there is no default, or what exactly the recourse is. So I think it is very important for any entity to enter into contracts and have well drafted contracts for any business transaction.
I think this is a keyword, well drafted, because generally we have seen a lot also with IPRs, particularly with patents, where the patent applicants try to save up money, they do their own drafts, and without actually having professional to look at these legal requirements, it can be disaster in the future. So my idea, or when I talk to young people or small companies, I always say they should look at these things as an investment for the future. So although it might cost them money now, it might cost them to go to see the lawyer, it might cost them to go to see patent attorney or any other attorney. But if it's done well, they will benefit from it in the future, as opposed to spending 1/3. Somebody do it for them for 5,000 rupees, and then later when the dispute comes, you find out that it's not enforceable, for instance. So I think this is a good takeaway message for the companies, to have a well drafted contracts or intellectual property rights. So what are these typical contracts which MSME can be expected to enter into?
So Hannah, the thing is that any transaction or any business relationship with which a startup or MSME enters into should have a contract. But typically, see, there are 4 or 5 different types of contracts which, irrespective of the sector or irrespective of the size, most people get into. So one is essentially between the entrepreneurs, between the partners who are starting the business. So it could be a shareholders agreement in relation to a company, it could be a partnership deed in relation to a partnership firm, and a LLP also needs a partnership deed. So that governs the inter se relationship between the partners who are entering into a contract. Besides that, once you employ people, you need employment contracts, which should clearly define what the role of the person is, what his remuneration will be, what his obligations are, how he can be terminated, what are the penalties and all that. Then you hire people, you hire consultants, you need service contracts with them, so that their role is well defined, your role is well defined, what their service levels are, what their deliverables are, all those things are defined. If you are into manufacturing, then probably you need a distribution agreement or a supply agreement where you are supplying your own product. In those cases, you clearly need to define what the where a particular distributor is supposed to sell his product, what the territory is, what the term of the contract is. So all these things bring a lot of clarity to your whole business. Then especially for startups, then once your investors start coming in, then you need a proper investment agreement, which could be in terms of shareholders agreement and a share subscription agreement, which again is very important, and where I would really suggest that all the startups should seek legal advice and not do it on their own, because at the end of the day, this agreement will govern your relationships with your investor. So your rights, you being the founder, you being the proprietor or the owner of the company, you had the idea. But if this agreement is not well drafted, so your rights could be really diluted. So for once your investor comes in, so what the kind of agreement you need with him, you really need to have good legal advice for it, so that your rights are protected. Because see, you may have number of investors coming in, but at the end of the day, as a founder, as a CEO, you need that the company remains yours. You have dilution, but to a large extent, you call the shots in the company. So obviously, you need that kind of contract drafting, and you need a well-drafted contract once the investors come in.
Thank you, Siddharth. We have a last question. So before we proceed with that, I would like to ask all the participants to share if they have any questions. We already have a few questions for Siddharth after my last question. So please don't hesitate. We have another 15 minutes where Siddharth can kind of advise you on your issues. So take this opportunity. So, before we wrap up from the official part, so the last question would be to you from my end, Siddharth. When we spoke about the well-drafted contracts, what are the essential terms and conditions you have to consider when drafting them?
See, while drafting a contract, one, it is very important that rights and obligations of each party are clearly given. So if somebody is going to supply some material to you, it should be clearly mentioned that what the material will be, when it will be supplied, how it will be supplied, how he will give the delivery. Similarly, for a service contract, it should be clearly mentioned that what is the expectation from you as a service provider or from the third party from whom you are taking the service, so that there is no ambiguity with regard to that. Then obviously the most important thing, the consideration clause should be very clear, that when the payments are due, when the payments will accrue, in what cases the payments can be withheld, how the payments will be made. So all those things should be clear. Then what are the penalties in case there is a breach? Because obviously every breach will not lead to a termination, because in which case your business will not move forward. So obviously there are certain mitigating penalties, or there are certain things which contracts do capture in cases of breaches which could be rectified. Then it is very important to define a term. Very often we see there are contracts in perpetuity which is not a right strategy. So obviously it is important that a term is defined, and maybe you can have a clause that parties mutually will renew the contract. So because situations change, you may need to revisit the commercials and all that. So if in case your wording is such that this is a contract in perpetuity, so it sometimes becomes difficult for parties to enforce their rights. Then termination clause should be there, because in most contracts we see that parties have omitted to have a proper termination clause. Now this termination clause has to be balanced, which balances that either party should have a right to terminate the contract on happening of certain event, or maybe I just want to terminate the contract, in which case I should have a proper notice period so that the business does not suffer. There could be certain clauses in cases of termination where you may need to give some assistance. I need to change my vendor, so in the interim period, the present vendor will give some assistance. So it is very important to draft this. Then for distribution and IP agreements, it is important to define territory, that where all I can distribute the product, or where all I can use the IP license, in what territory. because in most cases it is not given across the world. So that territory needs to be defined very clearly. Then very important governing law, that in case the agreement is between two entities which are in different countries, so you need to define the governing law, because then otherwise you will say the Indian law will prevail, the other party will say from whichever country they are coming. So you need to define that governing law. You need to define the territory, that in case of dispute, where the cases will be filed. So that is also very important, because otherwise that gives certainty and clarity to the parties, that if I have a dispute, where I can file a case. Now, very importantly, because we know how legal system in India works, you could also consider having a mediation and an arbitration clause in your agreement, so that things move quicker. And with regard to, as we've seen in pandemic, a very important clause, force majeure, has come up, that in case something happens which is unforeseen and nobody expected that there could be a lockdown due to pandemic, and the business definitely suffers. So if that kind of thing happens, then what will be the recourse? So all these things are important. Then again, for the startups, IP clause is very important for especially for research organizations or companies where a lot of research is happening. You need to have a proper, well drafted IP clause, so that the intellectual property remains with the company and does not goes away with the inventor, who may be your employee or who may be one of your consultants. So it is very important to put that clause, that the intellectual property is with the company. Because in the startups and MSMEs which are tech oriented, technology is the most important thing which drives the valuation of the company. So these are some important clauses which we need to keep in mind while drafting the contracts. Otherwise, it purely depends from transaction to transaction what the business is. So at the end of the day, because of contract, your business should not suffer. So your business has to be kept in mind. So we cannot be rigid about these things, but at the same time, we need to be protected from future disputes between the parties.
Thank you, Siddharth. I would just add to
one more thing I would like to add here is,
yes,
which I wanted to speak about with regard to MSMEs, is the registration under the MSME Act.
Okay.
So which is very important. So the MSMEs, as we all know that MSMEs have been defined. So it is important that we register under the MSME Act. Now this MSME Act, one big benefit is that once you get registered under MSME Act, the person who's to make payments to you needs to do that in 45 days. And there is a dispute resolution mechanism inbuilt in the act, which can be explored in cases of disputes. So I think it is important that a lot of these MSMEs and startups do consider registering under the MSME Act.
Thank you, Siddharth. I would also add to the comments you had about the terms and conditions, that except for the IP clause, you should also have the confidentiality clause. If you're a startup which would have a certain degree of trade secret, you can say, having confidentiality clause in your contract is also, I would say, quite important. So we are slowly running out of time, and we have quite a few questions from the audience. MP Mathur is asking, in PVTV company, liability is limited to 0 to percentage of share or amount of share in company?
I think it is governed by amount of share in the company, what I have contributed, what my capital contribution is.
And personal assets are free from company liability in PVT Ltd.
Yes, the personal assets are free until and unless I give some specific guarantee to take some loan, where I give a personal guarantee, or in some cases where I have not complied with certain law and I am personally liable. But as a shareholder or as a director, my assets are completely safe from what company is doing.
Now, Bipin is asking, is an OPC, one-person company, a good way to start if you do not have partners, but you want to keep options open to bring in investors?
See, the problem with OPC company is that if you want to bring in investors, then you will have to convert this OPC company into a normal company. Because one-person company means that you only have one shareholder in that company. So OPC company works, it is basically a different form of sole proprietorship, which has a distinct entity, but you run it more or less as a sole proprietorship company.
Now we have from Ananta here. Many MSMEs also depend on simple MOUs instead of legal contracts. In case of a dispute, does MOU have any legal standing?
Yes, MOU is basically a different name for a contract. Any legal document which is signed between two parties will be accepted by the courts, provided it is properly stamped and it is properly signed by the both parties. So even if you have a MOU, that doesn't make any difference, and it can be enforced in the court of law.
Yeah, that's all our questions actually. So if anybody we have few more minutes left, have some other questions, please do ask. Maybe before we wrap it up, Siddharth, do you have any kind of case study as an example what can go wrong if you don't either do your compliance or don't draft the contract well, some experience from your legal practice?
See, a lot of times we see that the contracts are not well drafted, in which case there is a lot of ambiguity between the relationship between the parties. So what happens is, if it is an ambiguous clause that this can also happen and this can also happen, so that is not easily resolved by the parties, and it is not easily resolved by the courts also. So in those cases, things get dragged, parties get into dispute, and really once you get into a dispute, then getting out of dispute is also a very difficult task, where one of the parties will have to give up certain rights. So as long as you have a basic certainty in contracts, it always helps, because then it is also easy for the courts to interpret and to understand the contract and to adjudicate on it. But if it is ambiguous, then things are not so easy. So it will keep dragging and your business will suffer. See, at the end of the day, what everybody needs to keep in mind is that business has to be run properly, and it cannot bog down by your litigations and because of your courts. And see, at the end of the day, compliances are also important, because we've seen many times that investors actually refusing to put in money in the companies where in the due diligence they found that the compliances were not done properly, or the contracts were not proper, and there were certain other obligations which the founders told them that these are not captured in the contracts, but there are oral commitments and all those things. So I think all these things, from a startup or a MSME perspective, as you rightly put, that these may be considered as costs, but really these are investments, so that your business is foolproof, it is run properly, and it is protected. And one more example I can give is not having a proper IP assignment clause in the agreement, where there are a lot of disputes where people, after leaving employment of the company, have come back and claimed intellectual property, that this was invented by me, and there is no actual assignment clause in my employment contract. So yes, these things are important, and these things do have a bearing on future of the company.
And I think especially for startups, when you have a group of friends or you have a group, of people, and when you are maybe young, you don't think about these things. But as the business grows, there is more money involved. This is when it then can get also complicated in the future. So probably, being transparent about these things in the beginning can solve a lot of issues at the end. On many fronts, and IP in particular, I would say.
Yes, right. The founders agreement is really important, because see, as you rightly said, initially everybody is a friend, but once the business starts growing, the commercial interest takes over the personal interest. So I think that is an important thing.
Yeah, to have the the discussions when we are still young and adjustable, and we have clear mind what we want, and have these kind of decisions, so the issues are kind of you can say resolved even before they happen. Right. So yeah, so I think we are kind of at the end of the session. Siddharth, thank you. I mean, we still have a few minutes. If anybody
Hannah, there is
Ashish,
one more. There is one more question from Professor Suhas Gazre. He is
Okay.
asking about importance of force majeure clause.
Yeah.
Yeah.
So, sir, force majeure clause earlier was not given importance, but after the pandemic, it is probably the most important clause now, which is negotiated by the parties. Because what we force majeure essentially means act of God. So this is something which nobody anticipates that something could happen, and because of which my obligations or my rights in the agreement suffer. So if there is a lockdown, obviously I will not be able to run my factory and I will not be able to supply the products. So force majeure clause is for those particular situations. Typically, parties give each other certain time, and if there is a force majeure clause, then it is not considered to be a breach of the contract. So that is why it is very important.
Yeah, there is one more question. Meanwhile, we got from Mr. Kushal, sorry for pronunciation. And he's asking if an idea has social impact, one would like to proceed as a profit and non-for-profit organization. What are the key aspects to consider, especially with respect to key people, founder, and the objectives?
See, now, if you have a social impact, then you really need to decide whether you want to have a for-profit organization or you want to have a not-for-profit organization. So not-for-profit organization is typically a Section 8 company, which is a specific section under the Companies Act, where you are not allowed to take any profits. So whatever you earn goes back to the company. So essentially, you need to decide on that first. But we've recently seen that a lot of social impact ventures are for profit, so that people are interested in those ventures. Okay, people with a lot of spirit to do good things. If there is a social impact venture which is for profit, where people make some amount of money, that has a greater likelihood to succeed than from a not for profit venture. It keeps people interested. And with regard to other considerations, you really need to take a call that how much profits you are willing to take, and how much what kind of social impact, what kind of difference you want to make to the society. So a lot of things depend on that.
And I have a last question here from Mr. Iyer here. For the mediation clauses in the legal contracts, are there any established arbitrators in India? Is it mandatory to mention the name of the arbitrator in the contract?
No, it is not mandatory to mention the name of the arbitrator. So you can just say that if in case of any dispute, it will be 1 or 3 arbitrators, one arbitrator to be mutually appointed by the parties. In case of 3, each party appoints one, and the third is appointed by the 2 arbitrators. There are arbitration centers in the country where arbitration can take place. So they have a list of arbitrators, but you don't need to name any specific arbitrators. You can certainly name, if you have a preferred arbitration center, you can name that this arbitration will take place under the rules of this arbitration center at this place.
Thank you, Siddharth. I think we are kind of pretty much at the end of this session. Thank you very much. I hope that with this, we can say nearly informal setup, we could inform our participants about this generally considered dry topic of legalities. And I'd like to, Siddharth, thank you for coming aboard and sharing your thoughts and your experience with us. It's really appreciated. Of course, if you, any of you who are listening to us want to reach out, please reach out to me, Hannah Onderkova at ebtc.eu. If you have any questions for Siddharth, I can pass them to him. And Ashish ji, do you have any kind of last words for our participants before we say bye?
Yeah, I would like to thank all the participants and especially the team from SGGS College, Joshi sir and Mr. Suhas Gazre for supporting this today's session. And I would also like to thank Siddharth for such a wonderful presentation in such a short time. I'm sure all the participants have got new insights on contracts connected with startups. Thank you. And of course, thank you, Hannah and Ankita, for the wonderful series which we are conducting right now, this Thursday talk series. Thank you. And we look forward for the next session
next week.
Yeah.
Yes, please join us for next session next Thursday. And there are a few more on IPR, on taxation, internationalization. So something new to look forward to and kind of get to know new information. And again, thanks to Magic and CII for their support as always. So everybody have a nice, now we can say evening, and we look forward to seeing you next week. Thank you. Bye.
Thank you, Anurag, for the excellent support as usual.
Yes, yes.
You're most welcome, sir.
Thank you.
And thank you, Anna.
You're welcome. Thank you. Bye.